A media company spends thousands of dollars every day to gather, verify, and print highly lucrative commercial data. And every morning, a competitor buys a single copy of their publication, extracts that exact data, and republishes it for their own profit. This is exactly what happened in 1960 between two giants of Australian publishing, John Fairfax and Sons, publishers of the Sydney Morning Herald, and Consolidated Press, publishers of the Daily Telegraph. At the time, Fairfax operated a vast portfolio of publications that reached audiences across the continent. But the specific battleground for this legal fight was a few narrow columns of text, the daily birth and death notices. These routine announcements drove massive daily readership. Families bought the paper specifically to see their names in print, and that guaranteed audience allowed Fairfax to charge premium rates for the surrounding advertising space. Maintaining this market dominance required a massive physical and financial infrastructure. Inside, a dense human workforce was tasked with gathering the raw material. Clerks spent hours on the phone taking dictation, verifying details, and typing up thousands of individual notices by hand. Consolidated Press entirely bypassed this expensive collection process. They simply purchased the early morning edition of the Herald, stripped out the names and dates from the notices, and sent them straight to their own printing press. The immediate instinct is to view this as obvious theft. One company is freely exploiting the expensive, hard-won labor of a direct competitor. But the Australian courts disagreed. They ruled that under copyright law, Consolidated Press had done absolutely nothing illegal. The ruling established a strict parameter. In intellectual property law, extracting immense commercial value from a rival does not automatically equal copyright infringement. To see how the court reached this conclusion, we have to look past the newspaper as a whole and examine the fundamental unit of the dispute, a single birth announcement. Copyright protection requires a legal threshold called originality. This means the person claiming the copyright must have originated the specific expression of the text. This diagram shows the anatomy of a standard birth notice. It breaks down into raw, unoriginal variables, a family name, a date, and a hospital. Justice Myers asked a very specific question: who actually dictated their syntax and selection? The answer was the advertiser. The parents or family members called the paper and supplied the exact wording. The newspaper clerk on the phone performed a purely mechanical role, taking down the dictated facts exactly as stated, adding no independent creative input. Because of this, the newspaper cannot claim to be the author of the text. Without any independent intellectual effort applied to the phrasing, the publisher holds zero copyright over the specific words in the notice. A routine, fact-driven announcement dictated entirely by a third party simply fails the test of originality. While a single notice fails the test, the legal status of the entire printed column is evaluated differently. When thousands of these unprotectable facts are gathered together, a new type of protection can emerge. This is known in copyright law as a compilation. As this diagram illustrates, it takes specific intellectual labor to arrange thousands of disconnected facts into a cohesive, searchable structure. The publisher creates this structure through alphabetical sequencing, categorizing by event type, and designing the visual layout. The newspaper does hold a valid copyright over this specific architectural arrangement. In 1960, this architectural labor was highly physical, requiring workers to manually adjust complex metal typesetting grids to execute the layout. Compilation copyright protects the author's labor of architecture. It does not grant ownership over the underlying data points contained within that architecture. This distinction between architecture and data is exactly what protected Consolidated Press. The legal test for infringement asks whether the defendant took a substantial part of the protected expression. This side-by-side comparison shows the plaintiff's original column on the left and the defendant's newly published column on the right. The mechanics of the extraction become clear. The defendant completely ignored the plaintiff's typographical layout and sequence, utilizing their own formatting. They isolated their extraction to only the raw variables. The names and dates were lifted from the Herald and dropped into the Telegraph. The plaintiff's protected arrangement, the actual architecture of their compilation, was never breached. The court found that extracting unoriginal facts from a compilation does not appropriate the author's protected labor of arrangement. Because only facts were taken, and the structural design was ignored, the court ruled that no substantial part of the copyright was infringed. The overarching rule of compilations is simple. Extracting raw materials is perfectly legal, as long as you do not steal the design of the building. This ruling confirms a foundational legal doctrine, the idea-expression dichotomy. This diagram illustrates the dichotomy as a strict, impenetrable boundary separating unprotected concepts from protected forms. On the unprotected side, we find ideas, pure facts, raw data, and the news of the day. On the protected side, we find original literary expression, unique syntax, and architectural arrangement. The extracted birth notices from this case fall decisively into the unprotected category. Fairfax attempted to argue that the immense financial cost and physical labor required to gather this data should warrant protection, an argument known as the sweat of the brow doctrine. Australian copyright law explicitly rejects sweat of the brow as a justification for copywriting raw facts. The law is designed to reward original intellectual expression. It is not a mechanism to protect the financial investments or hard work of data collection. 60 years later, this distinction governs the modern digital landscape. Fairfax versus Consolidated Press laid the legal blueprint for how courts handle contemporary data extraction and API disputes. An API, or Application Programming Interface, is a software mechanism that allows two different applications to communicate and share data. Today, competitors can legally scrape raw data, like pricing metrics or user statistics, from a rival's website. They can extract this data freely, provided they do not replicate the website's source code or mirror its specific database architecture. The law intentionally prioritizes the free flow of information over protecting a single company's commercial data monopoly. In the eyes of the law, facts belong to the public domain, regardless of who spent the time and money to publish them first.